Following the expiration of the 3-year tenure for local government officials in Rivers State on June 17, Governor Siminalayi Fubara directed heads of local government administration to assume control of the 23 councils. Now, this move comes amidst a web of legal complexities and a power struggle between the governor and the State House of Assembly. The outgoing council heads, reportedly loyal to Fubara's predecessor, Nyesom Wike, have vowed to remain in office after their terms ended. Now, this defiance stems from a recent amendment passed by the Assembly extending their tenure until new elections are held. However, the governor has not signed this legislation, raising questions about its validity. Now, Fubara's decision to appoint administrators has sparked concerns from legal experts. Critics argue that the move is unconstitutional and a disregard of the rule of law. Additionally, there are worries that Fubara is ignoring court rulings and disrupting the separation of powers between the executive and the legislative branches. This evening, Kudus Alalafia Esquire, head of chambers, Chinedu G. Udori and Company, Clemence's Associates, joins me from Abuja to unpack this. Thank you so much, Kudus, for joining us on the show.
Thank you very much. It's my pleasure to be here. Good evening, Nigerians. Thank you very much.
Nice. And we also have Shodbeye Eli, legal practitioner and public affairs analyst, Rivers. Gentlemen, thank you so much for joining us on the show.
Thank you for having me. It's a pleasure to be here again.
All right, so I'm going to start with Kudus. Now, let's start by looking at the validity of the Assembly amendment. Now, did the Rivers State House of Assembly possess the legal authority in the first place to amend the law extending local government chairman's tenure? And is it even backed by law? And would you say they followed proper legislative procedures?
All right, thank you very much. It is beyond doubt that the power to make law, to amend the law, to do anything with respect to formulation and the making of laws is vested in the legislative arm of the government, pursuant to Section 4 of the Constitution. But like I usually say, that for the fact that a part of the government has done something does not make that thing in itself the law. That thing must be done in accordance with the law. Now, we need to now subject the making of the law of this particular extension order by the Rivers State House of Assembly. We need to subject it to the legal test. Is it up to what we can actually say is valid under the law? Now, the procedure is that ordinarily, once it goes through their various sittings, from the first reading to the second reading up to the last stage, and they pass it to the governor for assent. If the governor decides to withhold its assent, then they can veto that assent. Yes, they have the power to do that. When they veto that assent, then they can now proceed to pass the pass the bill into law in absence of the governor. But one thing comes to our mind: the seats upon which the honorable members even sat to make this law is in question. And, there has been various court orders, one asking them to maintain status quo, the other one asking them to vacate and all what have you. I think in the interest of justice and in the interest of peace, why do not let us take this, let's take a step one after the other. Let's even assume, let's decide whether or not your seat is actually valid. Because it is when your seat is valid, that is when we can now know whether or not the law you have made, as at the time you are sitting, becomes valid or not. So while I would not want to, like I usually say, my own take is to look at the legal analysis without necessarily looking into the innuendos in this particular play. In my humble view, I would have suggested that in the interest of peace, let the the local government chairman, let them set aside for a bit, so that by the time they set aside for a bit, let the court take a decision as to whether or not the seats of the members that extended their tenure is valid. When that one takes effect, when the court says, oh, your seat is valid, then we now come to, okay, whether or not the law which the members had made was valid or not. But like I say, if the court find that their seats was valid, they are still honorable members of the House of Assembly of Rivers State, that law takes precedence. Because even if the governor does not give his assent, they can veto it. Okay. But if the court find out that they have lost their seat by virtue of cross carpeting to another party, then they lose their power under Section 4 to make law to extend the tenure of the chairman. Okay. Thank you very much.
Okay, so let me get a reaction of Shogbeye on this. I'd like to find out from you, just as Kudus has said, do you also align with the thoughts that the sitting that actually passed a law extending the tenure of the council chairman, would you also say that that sitting is either valid or not? We have to wait till June 20 before we get the final verdict on that, but then we need to put this into legal considerations. What are your thoughts?
Brilliant submission from my lady brother, Kudus. I must commend him for his deep insights. I haven't said that. Let me also say this. What will happen tomorrow, June 20th, has nothing to do with the declaration of the seats of the lawmakers, vacant or non-vacant. What will happen tomorrow, the appeal court is taking a further look at the applications made by Martins Amewule and others who are contending with the chair of the High Court of Rivers State to put them on hold. Recall that before my Lord, the Honorable Justice Charles M. Wiley of the High Court of Rivers State, Victor Kojumbo, having emerged as Speaker of the House of Assembly of Rivers State, following the defection of Amewule and others, had sought a judicial pronouncement to seek to restrain Amewule and co. from continuing to parade themselves in the face of the plethora of legal contention for their validity to sit, having defected to the APC in early December of 2023. Now, whereas that is the position, Victor Kojumbo came by way of his party motion, and the court granted an interim injunction and then progressed to adjourn the matter, asked the claimants to put defendants on notice, which is Amewule and co. Were put on notice and they came to court by the legal representation. And then the order was upgraded to interlocutory and then adjourned for further hearing on the merits of the matter. But upon the first step, which is the interim injunction granted, Amewule and co. proceeded to the appeal court, seeking for a stay. Of course, they had the 11 reliefs they sought. Now, at the last sitting of the appeal court, when the appeal court took the first bite of the cherry, the appeal court granted what I want to call a mandatory basic baseline prayers of extension of tenure, sort of time to file and compile records, do that basic issues about having the proper appeal before the court. Whereas they did that, the ones that had to do with going to the root of the issue, which is to set aside all that Victor Kojumbo had done. With respect, all of those issues are proper to evacuating the injunctions granted by the High Court. The court refused to go in there because the court was of the view that going there will amount to prematurely aborting what was before the High Court of the state and adjourned and asked the party to maintain the present status quo. How that has become a confusion, we don't understand. The court did not bother to look at whether or not Martins Amewule was a proper person or whatever to do whatever. When they go back to the High Court look at that on the merits. However, with respect to the issue before us now, on whether or not local government tenures, which are flux with time on the midnight of June 17, are still valid, and whether the governor could go ahead. I hear you in introduction say the governor was acting like a macho man was breaking the law. I don't agree. Respectfully, I don't agree. The House of Assembly had gone ahead to extend the tenure of these local government people who are inaugurated in June of 2021 for a 3-year term by Rivers State Local Government Law of 2018. Now, I haven't done that. two council chairmen, one for Bonny and one for Bobonkoro. Bonny is something Claude Wilcox. That is a lady. The guy for Bobo is Anyeda Kukigam.
Okay.
The approach is called for competition of the law, when the attendance should end in the face of this amendment. And that was before my Lord, the Honorable Justice Daketima Gabriel Kyo of the High Court of the River State. And my Lord, in his wisdom, said that amendment was inconsistent with the provisions of the Constitution. All right? Went further to say that the Supreme Court had held in the case of Attorney General of Abia and 35 others against Attorney General Federation in 2001 that there can't be any tenure allegation in that wise. It didn't go into the merits of whether or not Amewele had the valid grounds to sit. It didn't go there. But it voided that amendment for being consistent with the Constitution and, of course, relying on that federal authorities, including the one I cited, and expunged that amendment. That amendment, particularly that section 9 of that River State Government Law number 5, 2018. It expunged it from the laws of River State, which is what they call River State Government Law number 2 of 2024. It expunged from the laws of River State. That's what they appealed, and that appeal will be taken tomorrow. When they said Minister of School, did they say nothing should happen again at the local government level? When the terms expired, the governor appointed the head of local governments. He directed that they should take over. And then moved on from that point to further directive, which is what happened today. I think I should make that clarification so clearly here.
Well stated. Now, Kudus, of course, we see that there is a tenure expiration for these local government chairmen. It is stipulated and it's a binding law. And you've also come out to say that the governor has the right to not assent to the amendment of that law. Now, let's look at it from the angle of the governor that you mentioned earlier. Does the Nigerian Constitution even grant Governor Fubara the right to appoint new administrators? And this directive actually contradicted the provisions of the 1999 Constitution and the River State Law number 5, 2018 regarding the tenure of local government chairpersons and councillors.
Thank you very much. Ordinarily, the position of the law is that the seat for every local government chairman shall be on elective basis. And of course, by the time your tenure expires, it is expected that the state, through its election umpire, conduct another election into that seat for another person to hold on. However, where there is a lacuna, the governor being the chief officer of the state, being the chief executive officer of the state, of course, has the power to fill in a vacuum. To say, he's not saying that they will be there to take over the affairs of the honorable chairman, who ordinarily ought to be there by way of election. But then what they are saying is that administrators, and if you look at, by what I read, the direction given was to the next most senior officer in the local government to take over the affairs of governance, pending the time the election is held. Even without the instruction of the governor, even without the direction of the governor, it is expected, because of course there is no vacuum. There can never be vacuum in governance.
Okay.
It is expected that the next person who is the most senior after the elected officers takes over. So for me, I do not see anything illegal, or I do not see anything unlawful. So far, it is not that the governor is bringing somebody outside. If it is established that the governor is bringing somebody outside the administration of the local government, then of course it becomes unlawful. But if it is the most senior officer who is going to hold in charge, who is going to be in charge, pending the time the the election is held, the elected officer is being there, of course, for me, it is in line with the law. Thank you very much.
Okay, so this is how I want to push this now. We know how it operates in the civil service or the public space when it comes to elections, people coming into power, and when their expiration terminates at that time and somebody else comes to take their place. Wouldn't it have been proper for the governor rather, to have allowed these these persons or personalities to stay in office pending the time an election is held? Because the actual matter is, if this particular issue is being ratified by the state assembly in the first place, and if those state assembly, those actually form the quorum that extended the tenure, if they actually have the right to actually extend the tenure because of the fact that they moved from party A to party B. Now, this case is pending in court. There's a verdict to be given. So why is it that the governor couldn't have just waited for a sentence to be given, allow these people to stay in their positions, an election is conducted, a verdict is passed, and we just allow, the court to just run itself legally, seamlessly, if I could put it that way, without any form of inhibition?
I want to urge you as the media to exercise the powers under Section 22 of the Constitution, so that you hold these people accountable. Government is not a private business. The governor of Rivers State, with respect, has the powers to appoint catered committees. It is provided for in Section 9 of the Rivers State Local Government Law number 5 of 2018, that where there's a lacuna, where elections are unable to hold, even law of contracts sometimes will have force majeure declared that are grounds for rescinding of a contract obligation by a party. Life is not cast in stone. This can happen that will make a thing set by law not possible. Even pregnancy terms, not every woman that takes in a baby delivers at 9 months on the dot. Estimating factors will arise, and the woman may be unable to deliver at 9 months, sometimes before 9 months. So you deal with the situation as it arises.
So are you saying there's a possibility that elections will not be held as at the time stipulated, and that's why the governor had to take that drastic decision?
My friend, let me say this for you so you understand. I'm in Rivers State. See, as I say, everybody, I mentioned here that as a media, you should play a role in the Constitution. The judiciary had an opportunity to abort electoral violence in Rivers State in 2015. It did not do so. Now we have a very terrible environment where if you hold elections now, head to roll. That's the security agency in Rivers State, what they have in their hands. So if the governor, who is chairman of the Security Council of the state, has a meeting, and it's not possible. Remember, I had a meeting with the Security Council yesterday. Before then, they were having meetings. If the environment is too hostile to hold elections, what do you think you should do? Merely taking over council became an issue. Now, the body that's allowed by law to conduct elections is the Rivers State Independent Electoral Commission. The fellow that should speak on this issue about why they are unable to conduct elections is the chairman of RISEC. And may I also inform you that between March 2004 and October 2010, I served as an electoral officer in that agency in charge of a Momalo government area where 2 policemen are reported to have been killed in course of yesterday's fracas. Now, I've spent over elections that proceeded 2 local government chairmen. One is Nkanocha, the second was, that was in 2004, and then the last is his brother, his cousin, Jonathan Cha, in 2008. So we know what we're talking about here. If RISEC is unable to conduct elections, RISEC will tell the world if they are not financed, they don't have the logistics to run elections, that will know. But the governor as chief executive of the state, like my brother Kudus pointed out, has an onus responsibility to run the Rivers State. Now, don't forget, the House of Assembly that is now a distraction can sit. Those who are a distraction can stay away until the court decides otherwise, until INEC says it's time to run elections. Section 102 empowers those who are available to sit. We cannot hold Rivers State down that nothing happened because 27 people decide to be loyal to one man and not to the states and vote to their feet to join the APC. Now, caught in the web of legal tussle, they're beating the backtrack. Even will have the affidavits before a federal court before my Lord, the Honorable Justice Okoro in Abuja there. They're not saying they did not defect. All of this childish. All of this is childish. And the rest cannot be held down by anybody's whim and caprice. So what we're doing here is simply this. Tenure had lapsed. That's why the governor can, on his own, extend the tenure of somebody whose tenure is defined by law. The governor cannot do that. The governor will be running foul of the law if he does that. Wow. That's why on the 9th, the tenure expired. It was a public holiday, so there was no presidential National Assembly. He directed the heads of local government should take over. And then after, he had sent a list to the Assembly, the Validity Assembly, and they screened, and they had sworn them in. In this charge I had him, the electoral agency will set in motion to conduct elections. Whatever encumbrances they had, we cleared. Unfortunately, they could not handle that. In the midst of that attempt to impeach the governor between October last year and now, it must have been a boiling cauldron. The whole elections had to roll here.
Okay.
So they have to make sure they weather down the tides, beat down the heat. If I can hold an election, you want to call an election per se. At the moment I speak here, these issues here are not the environment is not that safe for what you want to call an election to hold. In any event, you know, as I know my name, that the elections here are of a different breed. You know what happened in River State here? The Supreme Court said the elections in 2015, before, after, was like a war. But the Supreme Court went ahead to uphold that election that brought Wike to power.
Okay.
Now, a precedent has been set. You usually have an opportunity to correct that, they don't do that. So elections have become a do-or-die thing.
Okay.
So at that election, the governor does not control the police. You have to be careful about what you do to put citizens at risk.
All right.
If the committee is part of the local government law, Section 9 is there, so it's not illegal.
All right. So, Kudus, as a legal luminary, let's look at this in terms of the separation of powers, because we know that there's a possibility that the State Assembly will not go down without a fight. So, in the light of this action by the governor of Rivers State, can the State Assembly in this situation also bypass the governor's veto, probably form a quorum, and enact the amendment on their own, extending the stay of these chairmen? I know it's going to be cumbersome when you look at it from the legal angle, but you know that they will not also keep quiet on this matter. Is that a possibility?
Okay, thank you very much. Based on the principle of separation of power, if the members of the House of Assembly of Rivers State, if they form a quorum, that means, because as we all know, I think the ones the governor is working with, I think they are less than 5.
5, yeah.
So if they form a quorum, then they can bypass the governor. Of course, that's if you check section, I think 56 or 58 of the Constitution, which talks about issue of vetoing the power of the assent of the governor. If the governor decides to say, okay, fine, I'm not going to assent to this law, take it off to this bill, they can veto it, call it again, and if everybody agrees to it, it becomes a law. But if they do not form a quorum, like I said, you cannot place something on nothing and expect it to stand. 1, 2. It is not whatever that is officially done that becomes the law. Whatever that must be done officially has to be done in accordance with the law. So if they form the requisite quorum, they can bypass. If they do not, they cannot.
Which actually falls under the requisition or the prerequisites rather of the law? What the State Assembly did in terms of extending the tenure of the council, or what the governor did, not accenting to that particular motion, and now having new heads, administrators come take their place. If you had to look at it, which would you say actually falls under the legal purview of the law?
Yes, you see, what we have in play is the principle of separation of power and the checks and balances. Mm-hmm. Yes, the principle of separation of power is saying that the legislature, executive, and judiciary, they have their separate roles. However, each of the organ of government should checkmate one another. And that is why in the instance where we have the legislature making law, then the Constitution requires that the governor should give his assent. So the same law is now saying that in the event the governor now, withhold his assent with or without any reason, they can also still veto his assent, veto his power to assent to that law and pass it into law without him. But it doesn't stop there. The same law allows the governor to sue the House of Assembly through the Speaker to the courts to nullify that particular law. So it's all about separation of power and the checks and balances, and where the fact and evidence, is in your support or not. But with all honesty, it appeared the governor has been, has been very, very dutiful with respect to what does the law says. So even though I know that whatever he also does also has some one or two political undertone, but the law tilts more toward its own towards his own side, more than that of the House of Assembly. I think if we want to be fair with ourselves, the mistake which the members of the House of Assembly of Rivers State did was to decamp. Because if they had not decamped, the issue of the legality of that law will not be in question. And even if it's going to be in question, it will not be, it will not be something that will be set aside on the basis that perhaps they are not valid members of the House. The court will have to look at what does the Constitution says with respect to, if you look at the section 9 of the Constitution, with respect to alteration of the law. So thank you very much.
Okay, so Shotbe, of course, we understand what the Constitution says when it comes to defection from a party to another, and it says that when that happens, that person, that candidate, will lose the seats. And people have questioned, why is it that it seems as though the law is being subverted to actually favor some people over others? I mean, it's white and black. You do this, this is the consequence. You lose your seat, you lose your power. Why do they have to take it to court to now begin to probe or question what constitutionally has been stipulated that must be?
Your question, my brother, was presuppose that I'm a lawbreaker. Who should know why he should subvert the law? I'm not a lawbreaker. Those who break the law know why they do it. But the basic principle is if you do the crime, you must do the time. Now, let me just forget one argument so I don't miss the point. The question of elongation of that tenure has been dealt with judicially. My Lord, the Honorable Justice DGQ of the High Court of Rivers State had nullified that law and expunged it from the laws of Rivers State. So anybody making any contention about tenure elongation is just being whimsical, with respect. It's just being one who's chasing the wind. The only area you can ventilate your disagreement with that judgment is to go upstairs and disagree with the Lord. He has ruled, and that's why the law stands. At the moment, nobody can stand on that tenure or alleged tenure elongation. He didn't even go into the merits of whether or not Amewula and Co. have a legal locus to sit as an assembly. He didn't even go there, but that was not a contention for him. So that said, if I were a judge of a high court or an appellate court, and the matter of section 109 sub 1G comes from me, I will, on the strength of judicial precedents, as allowed by our law and our practice, given the fact that that section of the law has been interpreted by the Supreme Court, in the case of Ifeda, Begude, and others against all those House of Assembly, I would decline jurisdiction. I would just say, no, I can't entertain it because it's Superior Court already spoken on it. Why we entertain further arguments on it is part of the setbacks in a legal system that foul-minded individuals abuse. They come to court to abuse court process, even when the court of that superior order as the Supreme Court has pronounced upon the section of the law. That is silent decisis. You don't need to contend with it. So if I'm a judge of the High Court that bring that matter, I will decline. So don't have people sitting down there to buy time for 3-4 years. If I respect, like my brother said here, the mistake they made us to was to defect. Now, if you go to section 191G, it did not say a court needs to make a pronouncement. It says when it defects in defiance of the laid down procedure or the facts that are set down in that proviso, you shall vacate the seat. It almost sounds like self-executory. So going to court to contend, and it's a bloody waste of time. And then it says in 109 that the speaker shall give effect to that vacancy, the moment the facts are brought before him.
Okay. All
right. So that had been done when my Lord, the Honorable Justice Monimata Gogo granted leave to Edison Ehie, his chief of staff, and he gave effect to that. I wrote to INEC. That was way back in December, and up to until now, not that been done. That's why today here the same people defected and not backtracking. But for me, the moment he defects and the law takes his course, will not be here. Right? And the state should be paramount. It's not about politics. The law is superior to politics. And if you're elected an office that is guided by the Constitution, stay on the Constitution and do your work.
Okay.
If you go outside the Constitution you. And that's what should happen here.
All right.
Buying time in the judiciary is playing politics, and it's wrong.
Well, that's quite interesting coming from you. Well, tomorrow we know that definitely a verdict will be given, and we get to understand if the 27 lawmakers led by Martins Amewule actually have the constitutional right to be in the assembly in the first place, and to also extend that particular tenure for the lawmakers, for the chairman of the councils. We get to find out and see if that will now translate, whether or not that particular move by them is valid or not. Now, we're actually out of time, so we might not be able to entertain any more response. I'm actually sorry.
That's not I said that is not going to be determined tomorrow. That's not before that pick up.
Well, we just have to wait till tomorrow. Let's just wait till tomorrow and find out. All right. Shodbeye Eli, legal practitioner and public affairs analyst, thank you so much for joining us on the conversation. And of course, Kudu Salalafia Esquire, head of Chambers, Chinedu, Abudora and Company, Clemence's Associates in Abuja. Thank you so much for sharing your thoughts also.
Thank you very much. It's my pleasure.